Good evening, Mr. Tompkins. Please come on in. Have a seat. Coffee? Coffee? No, not today. Okay. Well, unfortunately, I do not have good news today. The Supreme Court's ruling is not good for us. It not only ruled against us, but it actually changed the law itself that helped us win the $30,000 jury award for you. So how can I even explain this to you so it makes some sense? Let's go back to the beginning. Remember when I first took your case and I explained that by filing the case in New York federal court instead of Pennsylvania state court, a more favorable federal law would apply to your case and you would have a pretty good chance of winning the lawsuit against the railroad company. Well, that's exactly what we did, and the jury found the railroad company negligent and awarded you $30,000 in damages. Things went all according to plan, as they should when the Supreme Court tells you the rules of the game and you follow those rules. I knew that a more favorable federal law would apply because the Supreme Court itself said so long time ago. It's been the law since 1842, Mr. Tompkins, when the Supreme Court decided a case called Swift versus Tyson. And for almost a century, it's been the law of the land. Now, the Supreme Court says that the court got it wrong back in 1842 when it interpreted Section 34 of the Judiciary Act of 1789. That the court's previous interpretation is unconstitutional and must be overturned. Now the court says, and I'm just going to say what it says and then I'll explain it, that in diversity jurisdiction cases filed in federal court, when there's an on-point federal law from the Constitution, a treaty, or federal legislation, that law applies. But, and this is a big but, when there's no such federal law, the federal court must apply state law. So basically what the Supreme Court now says, that state law should apply instead of federal law in cases like yours. It said that it was necessary to make the change because the law invaded rights reserved by the Constitution to the states and created injustice and confusion. The interesting part is that not even the railroad company asked for that. We certainly did not. So what does this all mean for your case? Well, it means that instead of a more favorable federal law, a much less favorable Pennsylvania state negligence law will apply to your case. The new law does not only apply prospectively to old cases decided from this point forward, but it also applies to your case. Regardless of the fact that your case was filed under the old law, that the Supreme Court told us it was good law, your case was decided by a jury under the old law, went in front of the Court of Appeals under the old law, which again ruled in your favor. So what's next? The Supreme Court sent your case back to the Court of Appeals for the Second Circuit to apply Pennsylvania state negligence law. Unfortunately, that is bad news for us, really bad news. As I explained before, based on Pennsylvania law, you were a trespasser when you walked along the path next to the tracks. Based on that, the only way we can win is if we can prove that the railroad company acted recklessly or maliciously. That is very difficult to prove because we just don't have the evidence for that. Unfortunately, that means that the Court of Appeals will likely rule against you and you will not be receiving the $30,000 that the jury awarded you. And I'm so very sorry, Mr. Tompkins. I will keep you up to date as the case goes back to the Court of Appeals. And again, I'm very, very sorry.